In a letter dated December 5, 2017, Master Ruffiax forwarded to the scene's authority a signed power of attorney and requested an exemption from appearance in favor of the latter, while reiterating his request for legal assistance. False, due to the fact that Mr. Ruffiax never made contact with me in 2017. Months leading up to December 5, 2017, I was too busy with the USCIS and preparing for the spouse visa interview of December 5, 2017, and unaware of all the illegal activities simultaneously occurring in Switzerland. Q. In his submission of January 18, 2018, Devendra Prasad, through his attorney, filed his reply and in particular took the following conclusions. False, no attorney from Fribourg had ever contacted me, but the FOJ has records with Mrs. Hungerbuller office which I had been in constant communication with to file international protective measures to prevent kidnapping and fulfilling parental authority criteria for Hague access application filings for the wrongful withholding of my daughter. Ad 6. Disputed. It is found that Devendra Prasad's financial situation does not allow him to contribute to the upkeep of Layla Jaksic. Ad 7. Disputed. It is found that Devendra Prasad's financial situation does not allow him to contribute to the upkeep of the child Cassandra Amina. The preceding is false as Swiss parties were not in contact with me, but fabricating their own stories in court in favor of the Swiss mother. Between December 2015 and December 2017, I was the one carrying all the expenses of my family with over $50,000 of financial support and another $11,000 for U.S. immigration attorneys. Layla Jaksic said, the father has seen his daughter since birth 3 or 4 times in Switzerland. Between the father and the child it goes well during contacts by Skype. The father tends to attack me verbally during these contacts, which is why I prefer written contacts. The preceding is false, as my daughter was being prevented from all contact with me since December 17, 2017 by Layla Jaksic. LJ stated, currently I am fully supported by the social service. The preceding statement is false, social welfare fraud 42 U.S.C. 608A, as I had been financially supporting my family from December 2015 to December 2017 with over $50,000 total. Jaksic had lied to the hospital workers on August 16, 2016 when Cassandra was born. She told them that I was a friend, rather than Cassandra's father. Further proving the double life and deceit, LJ used a falsified birth certificate to prove her lies to the social services in order to fulfill their single mother criteria, and to fraudulently acquire social welfare assistance. The following copies of Cassandra's 2 different birth certificates bears relevance in this case, having 2 different names in using one certificate of the child's identity for financial gain. Fatherless Cassandra Jaksic was being used in Switzerland for financial gain, and Cassandra Amina Prasad was returning to her country of origin to be with her real family. Meanwhile, since December 2015 the Swiss family had kicked her out into the streets after finding out LJ was pregnant. CX12, Birth Certificate for Cassandra Jaksic. CX13, Birth Certificate for Cassandra Amina Prasad. The records prove that in 2017, the Swiss authorities, believing to have jurisdiction under false pretenses of LJ's opinions, assigned parental authority to both parents. Without my knowledge, Cassandra's birth certificate was used by LJ to unlawfully make a Swiss passport for Cassandra, issued on August 30, 2017. Cassandra's unlawfully obtained passport was used to abduct our daughter, without my knowledge, outside of Switzerland in October 2017, to Serbia for the mother to be with her lover outside of her marriage. Let the record show that Layla Jaksic Jasic is the only one making state-approved unlawful passports and doing the kidnapping. CX14, picture of Cassandra's Swiss passport, issued August 30, 2017. Continuing to prove entirely false contents of separation decisions of March 2017 and March 20, 2018, LJ stated, he had to pay me about father 2,000.00 over 2 years. I have no savings but debts for about father 5,000.00 in addition to social debt. The preceding statements are false, misleading, and defaming me as a delinquent father, not excluding perjury to the court. As the Livid Property Management invoice shows, the rent, deposit, and fees from June 2016 to November 2017 totaled $26,000. I have not included the multitude of bank statements, Western Union money transfers, wire transfers, credit card statements, proof of post-mailed boxes of baby food, clothing, electronics, and gifts, immigration attorney invoices for over $50,000 of direct financial support and $11,000 in attorney fees, because this file would be too large. However, investigations prove that LJ had another bank account outside of Fribourg, in Vevey, which had accumulated savings of over $10,000 and being kept secret by LJ and Switzerland's own secrecy laws. LJ also sold assets and kept the money along with the truth from Swiss authorities, the car I bought for her in August 2016 and, CX15, the $8,000 diamond and platinum ring that I gifted my wife while I was in Switzerland on February 14, 2016. The Swiss court violated my right to be heard, falsified its own documents, and decided solely on the opinions of Layla Jaksic to include false statements to facilitate criminal activity of the Swiss mother such as. The defendant agreed with the applicant's findings that the parties have been living separate since December 2015, c. 1, and that each of them has built up a home, Layla Jaksic, in Freiburg, ch. 2, and Devendra Prasad in Shoreline, USA, ch. 3, the preceding statement is false, referring to both of my residences, my home, and my family that was hijacked by the Swiss without authority to do so, especially in secret proceedings without my knowledge. A defendant would have to be a lunatic to agree to these findings after spending his life savings of $60,000 and defeating all odds to physically care for his family and child on the opposite side of the world, while petitioning the U.S. government for 2 years pending to safely bring home his family. 5.1. The defendant acquiesced to the applicant's conclusion that she should be granted custody of their daughter, Cassandra Amina. The preceding statement is false and refers back to March 2017 when LJ filed for separation and the court began acting in favor of her opinions. Meanwhile, I was building and decorating a baby bedroom in the USA in April 2017 and actively providing criteria for U.S. spouse visa for LJ and KP's return to country of residence. Whether it's the lawyer that the court hired to lie, or the court that lied, or the mother that lied, I was not ever given the right to be heard, I was not being notified of civil proceedings, and I was not a participant in these secret hearings and proceedings of 2017. Therefore, I never agreed to Layla Jaksic assuming custody of our daughter. I was too busy responding to the other side of LJ's double life of returning to the USA with Cassandra. Both parents permitted Cassandra to stay with her mother and contracted KP's return to the USA upon spouse visa approval, December 2017. While I was temporarily away from Switzerland and making plans with LJ over the phone of all the things we were going to do in the USA as a family when the US spouse visa is approved, received a postcard in Washington from LJ, dated June 26, 2017 further proving LJ falsified facts to the Fribourg court to obtain sole custody in Switzerland that was already being exercised jointly in the USA. After having filed for separation in March 2017 with contradictions and lies, CX16, on June 26, 2017, LJ stated in a postcard, "I am happy that you exist. My love, my precious husband, I love you so much and wish you every day more and more. It's a open wound in my heart to be separated from you for so long. I'm looking forward to start our new life together. May the universe be kind to us and reunite us together. Forever sending you all our love, TD, Lucy, Charlie, wife." For so long referred to, was only 4 months from my last extended stay in Switzerland as per the dates provided above in paragraph 2. Those are all my babies that Layla Jaksic promised and contracted with the USA to bring home. TT is Cassandra's nickname, Lucy our dog, and Charlie our cat. While her postcard of June 26 was still in transit to the USA, the tribunal's decision of March 20, 2018 states, see in a submission of June 30, 2017, Layla Jaksic filed a petition for protective measures of the conjugal union against her husband. 2. It is noted that Layla Jaksic has built up a home in Switzerland, in Pas de la Ploecha 3, in Fribourg. The preceding facts of June 2017 proves that I had no knowledge of what was going on in Switzerland behind my back, rendering paragraph D of the March 20, 2018 decision false. D. By order of July 4, 2017, the parties were summoned to appear at the hearing on September 18, 2017, and a deadline of August 7, 2017 was given to the defendant to respond to the June 30, 2017 motion. I never received any correspondences from any court of Switzerland in 2017, and I encouraged the FOJ to provide proof of service abroad to the U.S. Central Authority anytime in 2017. The falsified facts of paragraph D is actually confirmed in paragraph S, which also confirms all the statements from Konstantin Rufiaks of 2017 were not my statements. In an email dated February 8, 2018, the Justice of the Peace sent to the Scenes Authority various documents indicating that the defendant had contacted the Social Action Service, as well as the Justice of the Peace, to which he reportedly stated that he was not aware of this proceeding. The preceding also proves the statements of paragraph T, U, V to be false. T. In a letter dated 9 February 2018, Mr. Rufiaks notably requested the establishment of a supervisory board of personal relations in favor of the infant Cassandra Amina, availing itself of the agreement of the applicant party. U. In a letter dated 12 February 2018, the President stated in particular that, in the case of a procedure for measures to protect the conjugal union, the case was within his competence, not the Justice of the Peace. V. By order of February 13, 2018, Layla Jaksic was given a 10-day deadline to confirm the contents of the defendant's letter of February 9, 2018. Still unaware of all the secret civil proceedings being conducted for the previous 11 months, I was busy in the USA accumulating documents for the U.S. Central Authority in compliance of Hague Abduction Convention protocols. One such document was proof of marriage, the Washington marriage certificate herein, time-stamped February 2, 2018. The U.S. and Swiss Central Authorities attorneys, Mr. Adam Clark and Mrs. Francine Hungerbuehler, ignored or missed that detail of the marriage still being in effect, not excluding that secret hearings in non-compliance of Hague Service or Mutual Assistance in Civil Matters Treaty are in violation of international conventions and the main reason the first marriage was never simultaneously dissolved in the country of origin. The multitude of correspondences between myself and the U.S./Swiss Central Authorities in February 2018 will be included as attachments. However, X17 shows copies of the first and last page of my international child abduction application, Form DS-3013, dated February 4, 2018. While LJ was initiating divorce proceedings in Switzerland in March 2017, attorney Nicholas Cherrier was court-appointed to represent me without my knowledge at the time. Mr. Cherrier contacted me by telephone in April 2017 to let me know that he was representing me to obtain an original copy of Cassandra's birth certificate because my wife was trying to obtain documents for USCIS filings. LJ also confirmed that she obtained the lawyer, and when I arrived in Switzerland on May 9, 2017, paragraph 2 herein, we live like husband and wife still making plans to bring our babies home. 3 days prior to LJ's postcard of June 26, 2017, on June 23, 2017, Nicolas Cherrier wrote a letter which proves I was his client, but I did not know that he intentionally excluded the civil case number, lied to me about helping me to obtain Swiss documents for USCIS filings, but was actually helping LJ live a double life in fabricating a Swiss marriage certificate in 2017 without my knowledge or authorization. In breaking the law, oath, and ethics, Mr. Cherrier began representing the opposing party, Layla Jaksic, from 2018 to 2020, rendering an additional reason for the entire divorce case corrupted, null, and void. While the entire divorce has been fabricated to appear of domestic legal merit in Switzerland, breaches international law in fact that Layla Jaksic is presently married to 2 men, has children with both men, while polygamy and bigamy is outlawed in signatory states. CX18, correspondence from my attorney, Nicolas Cherrier, dated June 23, 2017. LJ provided the correct U.S. mailing address in X16 to the attorney to aid in her double life, while 3 months previously, she provided the Swiss authorities with a false address that would not be recognized and undeliverable in the USA, but returned to Switzerland. Proof of the false address that only LJ could have provided to the canton in March 2017 is depicted in the following correspondence from the Social Welfare Department. The evidence provided thus far proves Layla Jaksic is still married to a U.S. citizen, wrongfully withholding the U.S. citizen child, Cassandra Prasad, from her father's custodial rights, which is exercised by valid contracts with the U.S. government before and after she was born. The USA had official jurisdiction since filings by Kapoor Law Firm with USCIS, Department of Homeland Security, and Department of State in October 2016, prior to Cassandra becoming subject of Switzerland in 2017 with a pack of lies as its foundation, when the Swiss claimed unlawful jurisdiction and continued to breach international law by not contacting central authorities to legally serve me court documents in the USA, then continued to breach Swiss procedural law by never providing assistance in the English language. Never provided translations of any judicial correspondences, notices, transcripts, or decisions. The Swiss denied and continues to deny my right to be heard by omitting my statements and evidence. Swiss falsified statements, fabricated a Swiss marriage certificate in June 2017 without my knowledge while I was away from Switzerland with use of state-appointed attorneys acting on behalf of the state. I see why it would be necessary to not inform me of a pack of lies that were used to falsely implement Swiss laws that had no jurisdiction over my daughter to begin with. By perjury, fraud, misrepresentation, non-compliance of international protocols, and judicial misconduct, Layla Jaksic and Swiss authorities unlawfully kidnapped my daughter, dog, cat, and they all continue to treat Cassandra like a Swiss hostage kept away from her father. Divorce is invalid due to Layla Jaksic's acknowledgement of U.S. spouse, residence, and daughter immigrating to the USA. File number 10, 2017-1905, decision of March 20, 2018, by Judge François-Xavier Audergon, including paragraphs C to M pertaining to events of 2017 proven false herein, all prior proceedings of 2017, all following proceedings of 2018, 2019, transferred to VOD in 2020, 2021, 2022, 2023, Swiss Supreme Court decision, are all null, void, never have been in effect, never had jurisdiction, as Layla Jaksic maintains the validity of her marriage in the USA to Devendra Prasad and acknowledged me as her spouse/husband despite all the falsified facts contained in Judge Audergon's decision of March 20, 2018. The court declared. By order of October 25, 2017, the parties were summoned to appear at the hearing on January 25, 2018. Again, more lies, for I was not receiving any correspondences from Switzerland's courts or central authority in 2017, and X19, on October 3, 2017 LJ completed her final application with the USCIS, Form DS-260 Immigrant Visa and Alien Registration Application with the U.S. Department of State, case number Ben 20175090001, LJ declared. Current marital status, married, permanent address, name of person currently living at address, Devendra Prasad, U.S. address, 19011, 16th Avenue Northeast Shoreline, Washington, 98155, spouse's full name, Devendra Prasad, spouse's date of birth, December 1, 1979, spouse's city of birth, Georgetown, spouse's country/region of birth, Guyana, spouse's address, same as intended U.S. address, date of marriage, September 2, 2014, marriage country/region, United States of America, do you have any children? Yes, child name, Prasad, Cassandra Amina, date of birth, August 16, 2016. Is this child immigrating to the U.S. with you? Yes, petitioner is my spouse, petitioner name, Prasad, Devendra, country/region, United States of America. Do you have documentation to establish that you have received vaccinations in accordance with U.S. law? Yes, I visited the United States with an ESTA form of legal entry on August 9, 2014. Shortly after, Devendra Prasad asked for my hand in marriage. An I-130 petition was filed on my behalf during the time. However, I had to leave the United States during this time to attend to a family emergency in Switzerland. Because I departed during the filing process, I was barred from return due to overstay. Have you ever withheld custody of a U.S. citizen child outside the United States from a person granted legal custody by a U.S. court? No. Have you ever intentionally assisted another person in withholding custody of a U.S. citizen child outside the United States from a person granted legal custody by a U.S. court? No. On December 5, 2017, within the U.S. Embassy territory and during the spouse visa interview, LJ confirmed all the statements of her DS-260 application to a U.S. authority, as she wrote in X19 Form DS-260. Referring to the Swiss government's false observations of June 15, 2023. In response to government's observations of June 15, 2023, paragraph 9, the FOJ refers to the divorce decision of December 12, 2019, and it must be noted that the state-appointed lawyers were all informed that I was never given the right to contest the divorce nor notified of proceedings of 2017, but misrepresented me and failed to secure my rights in all appeals and filings. Grounds for my appeal has always been provided to Swiss lawyers, in which I stated that the Swiss court never investigated the false claims of the Swiss mother, the FOJ never fulfilled central authority duties nor take action of my claims of secret hearings of 2017. None of the parties can prove that I actually participated in their illegal activities and international law violations from March 2017 to January 2018, nor produce any correspondences received from Devendra Prasad in 2017. Paragraph 12 confirms the Swiss continuing to deny my right to be heard, omitting evidence, and falsifying facts. AC on behalf of the FOJ wrote, the cantonal court also modified the fixed maintenance contribution and ordered LJ to take appropriate steps to have KP status as an American national recognized. The preceding is misleading, for proof of the child's U.S. citizenship, along with U.S. government proof of the child being in contracts with the USA was previously provided to all parties. Ignoring my correspondences by Hague Access application of February 2018 emails and lawyer, the cantonal court made it look on record as if KP's dual nationality was not already established. Though KP was born in Switzerland, KP and LJ were already in contracts with the USA from the time prior to and immediately after her birth, involving matrimonial status and my custody of Cassandra Prasad. I provided the cantonal court and all parties a copy of KP's U.S. Consular Report of Birth Abroad, CRBA. It proved that KP's U.S. citizenship was retroactive from the time that she was born to a U.S. citizen, and lies of the court. Paragraph 4 herein above. CX20, copy of Cassandra Prasad's United States citizenship certificate. From the pack of lies generated in Fribourg to fabricate a Swiss marriage certificate with my name, secret hearings to produce lies on record while stealing my identity to fabricate an unlawful separation that was initiated 2 weeks after I was living together with my wife and child, to state aid LJ in robbing me of my money, assets, my daughter, dog, and cat, not notifying me of proceedings and filings in accordance to procedural and international law, from petitioning for spouse visa with the U.S. government to bring my family home, to discovering the double life of my spouse in December 2017, to informing the FOJ of all of the above since February 2018, to the pack of lies in a language that I do not read/speak moving to divorce filings 19 months after living together with my wife and child. By a lawyer that worked for me and then went on to represent the opposing party, the fake divorce case of LJ and DP having no foundation of legal merit, was then transferred to Canton Vaud in July 2020, Justice of Peace of the Riviera, Judge Eddie Vincani and his set of coursers at the Director General of Infants, and the Vaud Bar Association. Rather than addressing the FOJ's reiteration of the local annual predictable routine of corroborating family court scheme criminals covering up their child rights violations by defaming my character with absurd lies to justify their state-aided alienation of the father from the child's life in favor of the mother's opinions while their entire divorce case is invalid, null, and void as LJ's first marriage is still undissolved, and my custody rights to Cassandra remain in effect, I will herein return to the merits of law, which the FOJ, Justice of Peace, tribunals, and Swiss Supreme Court seem to have difficulty abiding by. Referring to another international protocol not respected by the Swiss, Hague Maintenance Contributions and or Collection, the Swiss have never once complied with the Hague Maintenance Protocols of 2007, since March 2017, clarified on the FOJ's website at the following web address. However, every couple of years, I'm sent an email, in French, to pay $10,000, I'm prosecuted for unpaid maintenance, sentenced and or fined jail time by a bunch of criminals disobeying the laws of the convention in illegal collection of money from the USA. As usual, I would remind the Court and Maintenance Collection Office of the legal method, which is to contact the FOJ. They refuse to send the invoice to the FOJ, and when I contact the FOJ directly, the FOJ refuses to do their job, as detailed on their own official website. This once again proves refusal by the Swiss to follow any international protocols whatsoever in their state-aided parental alienation campaign's strategic separation of an Indian father from his Indian daughter, an additional illegal method of preventing access, interference of access, and my daughter's CRC rights to access and maintenance. It is illegal to send unclaimed U.S. funds abroad, while I cannot claim it in the USA for being legally married to Layla Jaksic. In 2023, the Fribourg prosecutor, Mr. Mark Bugnan, dismissed the criminal charges for unpaid child support to cover up their non-compliance of Hague maintenance protocols, and made it look on record as if I am to blame for indigency reasons, while they have no financial records of mine. X21, Penal Ordinance by Fribourg Public Minister of June 30, 2023, which also references criminal charges relating to Mark Bugnan pretending to be an international prosecutor who enforces Swiss laws on a sovereign U.S. citizen from abroad, such as defamation, slander, and misuse of a telephone. X22, email of September 22, 2022, 5:14 a.m. Isabel.Staley@bd.ch wrote, Hello sir. We acknowledge receipt of your email below. Considering that you persist in not wanting to pay child support for your daughter Cassandra, legal proceedings against you will soon be filed with the competent authorities. Yours sincerely. X23, email, from kindestutes@bj.admin.ch to walkits1@aol.com. Date, Wednesday, June 28, 2023, at 8:28 a.m. Eastern Daylight Time. Dear Mr. Prasad, we are referring to your email below. As you know, we have closed your case under the Hague Convention. Because of the principle of separation of powers and the federal system of our country, we are not authorized to control the decisions or proceedings of the competent cantonal authorities in civil and criminal matter, to issue directives or to intervene in pending proceedings. Furthermore, we cannot comment on any pending or completed proceedings before the cantonal judicial authority. Your attorney at law will be able to advise you on your possibilities and the best way to proceed. Kind regards, Federal Department of Justice and Police FDJP Federal Office of Justice FOJ Private Law Division International Private Law Unit Bundesring 20, 3003 Bern, plus 4158-463-8864 Convention on Rights of the Child, CRC, breaches. International protective measures to prevent abduction of Cassandra Persaud prelude, precede, and take precedence over Switzerland's domestic measures.